My name is Dave Dobson. I was named by the Saugeen First Nation in their legal action to claim a portion of Sauble Beach in 1995. I have been researching the Saugeen Band's claim for many years, and I have produced this video to visually explain why the Saugeen Band's claim is not valid. To give you a better perspective of what I'm talking about, let's get our geographical bearings. Sauble Beach is located on the eastern shore of Lake Huron in Ontario, Canada, approximately a 2.5-hour drive by car northwest of Toronto. The Saugeen First Nation claim that a portion of the actual beach, approximately 1.5 miles in length, from the dividing line of Lot 2526 at Main Street to midpoint Lot 31, was never surrendered during the signing of Treaty 72 in 1854. For those of you familiar to Sauble Beach, the claim extends from Main Street at the Welcome to Sauble Beach sign north to a spot on the shore approximately 200 meters north of the white change rooms at 6th Street. The current boundaries of the Saugeen Reserve, looking north, as surveyed by Charles Rankin in 1855, are outlined in red in this photo from Google Maps. The same area claimed by the Saugeen Band that I showed previously looking west can be seen in this view looking north, represented by this line. I own the Crowd Inn takeout restaurant, and my restaurant and beach property make up a very small portion of this claim, approximately 50 feet of the entire 7,920 feet of beach claimed by the Saugeen Band. Nevertheless, since it is part of a native land claim, the federal government is required to investigate, and investigate they did. There are various incarnations of the department initially known as Indian Affairs, the most current being the Department of Crown Indigenous Relations. In this presentation, I will refer to the department as Indigenous and Northern Affairs Canada, or INAC, as they were known from 2015 to 2017. INAC have poured countless dollars into researching and supporting the Saugeen Band's claim since sometime during the 1980s. What they found initially seemed impressive, even irrefutable. However, since they were the only ones doing any sort of investigation, their account was never analyzed to detect flaws or what was missing from their research. In fact, no counter-analysis into this claim would be done until 2005. As a result, the federal government, represented by the Department of Indigenous and Northern Affairs Canada, initiated the claim on behalf of the Saugeen Band in 1990 against Amabel Township, now known as the town of South Bruce Peninsula. The private landowners were named in 1995 by the Saugeen Band. With no expert reports to champion the cause, the town and the private landowners were held hostage to the research of INAC. At that time, since the defendants had very little knowledge of the facts, INAC saw opportunity to take full advantage of the situation. Over the years, as the defendants became more knowledgeable, the public remained uninformed. INAC have not had their research challenged or even questioned by anyone throughout the media. During this presentation, I will show how on the surface the Saugeen claim, supported and researched by Indigenous and Northern Affairs Canada, appears conclusive to those unfamiliar with the evidence. I will then begin to point out the flaws in their argument, which should have nullified this claim 12 years ago. Lastly, I will offer an explanation never considered, built on facts, that conclusively refutes the Saugeen claim. I say conclusively because the argument I offer is the only possible way to match the Saugeen Reserve boundaries described in Treaty 72 to Charles Rankin's final survey map. Let's begin. This is the October 12, 1855 draft map, the most important piece of evidence to support the claim of the Saugeen Band. At first glance, it is difficult to believe that this map could cause so much controversy. But let me zoom in on one significant feature that makes this map stand out. The notation and post found at midpoint Lot 31 at the shore of Lake Huron. Most, myself included, would agree that this notation was meant to read Northeast Angle Indian Reserve, which would seem to leave little doubt that this is where the Saugeen Reserve's northeast corner is supposed to terminate. But let's keep in mind that this is a draft map, a working reference tool used by Rankin and his surveying team, not a representation of Rankin's final work. I can't emphasize this point enough. This is a draft map, not the accepted and certified final map. It wasn't even submitted to Indian Affairs. It was found in the Baldwin Room of the Toronto Reference Library. Nonetheless, since the notation seems to hold some significance to the northeast angle of the Saugeen Reserve, an investigation was launched. We can also investigate into the 1855 draft map's authenticity by simply comparing it to the terms of the treaty to see if the treaty terms agree to where the notation is located on the map at midpoint Lot 31. To demonstrate this, I will use the 1855 draft map in combination with the Ontario topographic mapping tool so that I can show you the 9.5 mile measurement. First, let's begin with the first treaty instruction. It reads, all that block of land bounded on the west by a straight line running due north from the Saugeen River, at the spot where it is entered by a ravine immediately to the west of the village, and over which a bridge has recently been constructed, to the shore of Lake Huron. The next instruction says, on the south, by the aforesaid northern limit of the lately surrendered strip. For the next treaty instruction, I'm going to use the Ontario topographic mapping tool so that we can get an accurate measurement for the 9.5 mile distance. As you can see, I have already put in the the western boundary and the northwest position, and we have the southern boundary marked in. So the treaty instruction reads, on the east by a line drawn from a spot upon the coast at a distance of about 9.5 miles from the western boundary aforesaid. Now it says to start from the western boundary, but since it's easier to move the mouse down rather than up, we're going to start at midpoint Lot 31. So we're just going to zoom in here to get our accurate location. So here we are at midpoint Lot 31, and we want to measure a distance in miles, and we are going to start right here. So we're measuring right along the shoreline. All the way from midpoint Lot 31 to the northwest position of the original western boundary. So I'm going to do this as accurately as we possibly can. We use a little room for error, but for the most part, we'll zoom in here a little bit. So we'll speed this process up a little bit. And then we can see what our measurement is. Approaching the northwest position to where we want to stop. And as you'll see, our measurement equals 9.62 miles. Now, I get variations in this measurement, but it's always within the range of, say, from about 9.5 right to 9.7 miles, depending on how accurate you get the shoreline. But it always ends up relatively close to 9.5 miles. So it is, as the treaty instruction says, about 9.5 miles. When we zoom out, we can see the 9.5 mile measurement from the northwest position of the western boundary right to midpoint lot 31, and we know it equals about 9.5 miles, just like the Saugeen Band claims it is. Now let's transfer the 9.5 mile boundary line to the 1855 draft map to complete our third instruction. We can complete the boundary with the final instruction from the treaty. It reads, "And running parallel thereto until it touches the aforementioned northern limits of the recently surrendered strip." You're probably thinking, what's your argument? The Saugeen Reserve boundaries on the map do match the terms of the treaty. They actually don't. First of all, I had to draw the original western boundary on the map myself rather than retrace it. It doesn't exist on the 1855 draft map. Without the western boundary, how can you determine where the 9.5 mile measurement begins if this is the map we should look to as the decisive piece of evidence to determine the Saugeen boundaries? Second, the eastern boundary from lot 2526 to midpoint lot 31 travels through the water of Lake Huron. The first sentence of the treaty terms regarding the Saugeen Reserve begins with, "all that block of land." Since the eastern boundary runs through the water from lot 26 to midpoint lot 31, the block of land ends at lot 2526, not midpoint lot 31. The shoreline from lot 2526 to midpoint lot 31 cannot be considered part of the boundary because it exists outside of where the block of land closes and terminates at lot 2526, now known as Main Street. Even if you were to insist that the part of the 9.5 mile shoreline measurement from lot 26 to midpoint lot 31 that is outside of the block of land should be included as part of the reserve, how would you determine the width of the shoreline boundary? There is nothing in the treaty description of the Saugeen Reserve that measures anything outside of a block of land. Therefore, there is no way to determine a width. Third, the only way to include the shoreline in the block of land is to deviate the eastern boundary off the true north line so that there can be a width of land that does include the beach from lot 2526 to midpoint lot 31. This would also go against the terms of the treaty because the western boundary runs due north. Since the eastern boundary is described as running parallel to the west boundary in the treaty description, the eastern boundary also runs due north. 4. The northeast corner of the Saugeen Reserve is clearly marked as terminating in the vicinity of lot 2526 Main Street. What could possibly have possessed Charles Rankin to terminate the Saugeen Reserve at lot 2526 on the very same map as the notation at midpoint lot 31, if midpoint lot 31 was the intended location? 5. The notation Northeast Angle Indian Reserve is inconsistent with the position on the same map that we know Rankin marked as an Indian Reserve boundary. If we look north to Chief's Point, we see the southeast position of Chief's Point eastern boundary marked simply as post. I would suspect it would be unusual practice in the surveying profession to mark an Indian Reserve with two different notations on the same map. Finally, a map that is intended to be an official representation of the treaty would be signed by Charles Rankin. This one is not, unless you consider these scribblings to be Charles Rankin's signature. Compare it to what Charles Rankin's signature really looks like. The map would also have the plan title correct. The 1855 draft map has Keppel stroked out and Amabel handwritten in its place. In July 2014, Nelson Phillips reported in a joint article that appeared in the Owen Sound Sun-Times and the Wyerton Echo the following quote from a May 2013 Saugeen First Nation newsletter. Almost all of the land along what is now called Sauble Beach was promised to us in 1854 as part of Treaty No. 72. This land was reserved for us, including the portion of beach just south of the mouth of the Sauble River. Charles Rankin drew a map of the township that records this information. The treaty, the survey, and the map all clearly mark the extent of our territory. This quote demonstrates that without the October 12, 1855 draft map, the Saugeen Band do not have a claim. I have already demonstrated, based on the draft map alone, there are major problems that put the accuracy of the Saugeen claim in question. The treaty and most definitely the 1855 draft map are anything but clear as to the extent of the Saugeen territory. The map has a notation that presumably marks the northeast corner of the Saugeen Reserve at midpoint Lot 31, yet the northeast corner is clearly defined as terminating in the vicinity of Lot 2526. The treaty says the 9.5 mile distance is to be measured from the western boundary, but where and how? Along the shoreline? In a straight line from the southwest position? In a straight line from the northwest position? Where? Yes, the measurement from the northwest position along the shoreline to midpoint Lot 31 is the closest to 9.5 miles. That is, if the northwest position was drawn on the draft map. For the Saugeen Band to say that the treaty and the draft map are clear as to the extent of their territory is certainly misleading. Without the western boundary labeled on the draft map, it appears that the Saugeen territory includes everything west of the ravine. The Saugeen Band are using the draft map to declare the extent of their territory is clearly marked when it isn't. The very parcel of land they are claiming falls outside of the block of land. If the western boundary had been included on the draft map, the treaty would have established a boundary that looks like this. Again, with the eastern boundary clearly running through the water of Lake Huron, the 1855 draft map and the treaty instructions are anything but clear. Enac and the Saugeen Band would have you believe that everything begins and ends with the original treaty instructions and the 1855 draft map. But they have disregarded some of the most important historical records that, unbelievably, before the expert report of 2006, were shoved aside by Enac as inconsequential. They make no mention whatsoever of the official and final map Rankin produced that does clearly mark the Saugeen Band's territory. The final authorized map marks the northeast corner of the Saugeen Reserve at Lot 2526, not midpoint Lot 31. More on the final map a little later. As for the Northeast Angle Indian Reserve notation itself, considering that the draft map's inconsistencies hinder analysis to provide a conclusive meaning, all we can do is speculate. That being said, based on the documented history of the survey, we can make some very strong deductions of its meaning. Could one of them be that the notation was intended to mark the northeast corner of the Saugeen Reserve? Yes, but in Rankin's mind, that intention was erased almost as fast as he recorded the note. I will agree, however, that the survey, although not without its complications, is relatively clear if you follow the timeline of events. Although the draft map is dated October 12, 1855, it was probably one of the first documents Rankin began working on. What would seem logical is that Rankin drew the shore outline on this map after he traversed the shoreline from the Saugeen River to the Sauble River in 1854. He measured 61 segments to accurately position the shape of the shoreline, much the same way I had to make short measurements on the Ontario mapping tool to record the shore outline. It would make sense that Rankin made note of the 9.5 mile distance at this time. He most likely realized the treaty instructions, as written, were not possible on this same traverse. Before I leave the 1855 draft map, I would like to point out one last detail that the experts either didn't notice or dismissed without analyzing. If you take notice of the eastern boundary extension line from Lot 2526 to midpoint Lot 31, you will notice that it doesn't stop there. It keeps going and extends to the Sauble River. You will also notice that it is drawn lightly compared to boundary lines, meaning it is a construction line, a line that doesn't exist on a map other than for its purpose. And what is that purpose? Well, it is not to make a connection to midpoint Lot 31. When I noticed how far the extension line traveled, I thought that I had found a different meaning for the northeast angle Indian Reserve notation. I thought that it was referring to the angle of Chief's Point running north to east. A cartographer pointed out to me that the angle of Chief's Point actually runs north to west, not north to east. However, my mistake enabled him to decipher why the eastern boundary construction line extension is there. When we look north to Chief's Point eastern boundary, a bearing reading is noticeable of north 11 degrees west. You can test the reading by putting a protractor on the eastern boundary line and the vertical line that is hanging down, which represents magnetic north. The Saugeen Reserve's eastern boundary represents true north. Rankin was not trying to draw attention to midpoint Lot 31 with the extension line. He was intersecting the true north line with Chief's Point eastern boundary to allow for a true north bearing reading for the final map. We can see the true north reading on Chief's Point eastern boundary on the final map of north 13 degrees west true. It is convenient that Rankin did include this extension line on the draft map, since it illustrates nicely the fact that the eastern boundary of the Saugeen Reserve cannot be contained within a block of land from Lot 2526 to midpoint Lot 31. Knowing what the extension line on the 1855 draft map is for, we can dismiss that Rankin is trying to point out any significance to midpoint Lot 31. The northeast corner of the Saugeen Reserve is established in the vicinity of Lot 2526 on the draft map, not midpoint Lot 31. It is most logical that the notation is simply that, a note made at the time of the October 1854 traverse, not a confirmed boundary position. The following portions of this video deal predominantly with the research I have conducted since 2016. Some of it, such as the Huff letter analysis, I began in 2006. But the bulk of my investigation began 3 years ago in 2016. Much of what I found was aided by the publicly available documentation found in the expert report, which supports the defense in this claim. Without it, I most likely could not have conducted my own research. However, as much as I respect the report, I still felt that it only proved the Saugeen Band's claim to Sauble Beach to be inconclusive, not invalid. I felt that the key was to prove the claim invalid. To me, the report didn't answer three crucial questions. They are: 1. How can the measurement from the original northwest position of the western boundary to the northeast angle Indian Reserve notation equal 9.5 miles and still not be the northeast corner of the Saugeen Reserve? 2. Why is the northeast angle Indian Reserve notation marked on the 1855 draft map? I have already dealt with what I feel is the most likely reason for the notation in Part 1. There is another possible reason that the expert touched upon without much detail. I will add detail. 3. How can the notation on the physical post at midpoint Lot 31, northeast angle of Saugeen Reserve according to treaty boundary running south, not be considered corroboration of the Anak-Saugeen Band argument? At the beginning of 2016, I was distracted by the meaning of the notation Northeast Angle Indian Reserve, which was the focus of my research for over a year. Some important discoveries came out of that research, but they pale in comparison to the revelation I had in November of 2017. Let's continue. As I have pointed out on the 1855 draft map, it is obvious, as written, the original treaty instructions were impossible to carry out. I discussed in Part 1 that Rankin most likely discovered the problems when he traversed the shoreline from the Saugeen River to the Sauble River in October 1854. To illustrate what Rankin intended to do in reaction to these problems, I will use the Grey Bruce map of January 1855 that I discovered online in 2016. It is also housed in the Baldwin Room of the Toronto Reference Library, the same library the 1855 draft map was found. As early as January of 1855, the Grey Bruce map shows that Rankin intended to relocate the northeast corner of the Saugeen Reserve to Lot 2526 Main Street and leave the western boundary in the same location the original treaty text had instructed. The map is signed by Charles Rankin, and there is a scale on the map that allowed me to verify the northeast corner is located at Lot 2526 Main Street. However, just by looking at the map, it is obvious that the northeast corner terminates at Lot 2526. Since I didn't have the authentic Grey Bruce map, I emailed the Toronto Reference Library to ask what the distance from the northeast corner of the Saugeen Reserve to the mouth of the Sauble River is on the map. They replied that it was 7/8 of an inch. By using the method shown on the screen, I could now calculate how far the distance was in miles. To verify the location as Lot 2526, I made the same measurement on the Ontario Topographic Mapping tool, from where the mouth of the river is shown to be located on the 1855 draft map. The distance is almost a perfect match. January 1855 is only 2 months after the signing of Treaty 72. Crucial evidence in the timeline of events that severely disables the argument of Anak and the Saugeen Band. The map was either simply ignored or its significance was never realized. Under proper examinations, its importance is obvious, but as a piece of official evidence against the Saugeen claim, it still remains to be ignored. It wasn't the fact that Rankin was planning on locating the northeast corner of the reserve at Lot 2526 Main Street that caused an uprising among the Saugeen Band in 1855. It was where he was planning to locate the western boundary. The band contended that under Treaty 72, they had agreed the northwest position of the western boundary was to be bounded by Copway Road and would be entitled to everything north of it. Anak and the Saugeen Band failed to mention this crucial piece of evidence. Crucial because it establishes where the 1855 Saugeen Band believed the starting point for the 9.5-mile measurement was to begin at the time of the signing of the treaty. The Saugeen Band's uprising, caused by the treaty's written location of the western boundary, led to a powwow at Floodwood Crossing, now known as Allenford. The disagreement was resolved by way of the Copway Road Amendment. The amendment reads, first, that the reserve known as the Saugeen Reserve, now bounded on the west by a straight line running due north from the River Saugeen at the spot where it is entered by a ravine immediately to the west of the village, be bounded instead by the Indian path called the Copway Road, which takes a northwesterly direction, as shown by the red line in the plan. This change will give the Saugeen Indians a small increase in frontage on Lake Huron. The Copway Road Amendment was commemorated by a plaque located in Allenford on Highway 21. If you are passing through Allenford, you can visit this site and read the plaque for yourself. Charles Rankin made a very important declaration in regard to the Copway Road Amendment that conclusively proves the Saugeen Band received what they were promised from the treaty. He said, "There would be no harm gratifying them and allowing them the use of it, which of course can be done without resurrendering it to them or in any way altering the terms of the treaty." When considering the evidence of this land claim, there is perhaps no other statement that is more important than this one to corroborate how Rankin created the boundaries on the final map. It confirms that the 9.5-mile distance is to remain 9.5 miles. Therefore, the measurement should not begin at the original northwest position, created by the line running due north from the ravine. It should begin at the northwest position of the western boundary at Copway Road, the same location the 1855 Saugeen Band originally believed they had agreed to when signing the treaty. I emphasize where the 9.5-mile measurement should begin because of the sentence from the amendment that says, "This change will give the Saugeen Indians a small increase in frontage on Lake Huron." Some will argue that the statement, "give a small increase in frontage," is meant to be in addition to the 9.5 miles already established from the original treaty instruction. This incorrect interpretation is most likely why so little consideration was ever given to the Copway Road amendment by the experts, and why they never discovered what I discovered. I mean no disrespect to the experts. Experts work under a timeline. I do not. I have had 27 years to absorb the evidence. It is understandable the wording of the amendment was misinterpreted, considering no one measured the Copway to Main Street distance to find it also equals 9.5 miles. Connect this to Rankin's declaration about the treaty not being altered in any way, and the evidence is conclusive that the northeast corner of the Saugeen Reserve ends at Lot 2526 Main Street. It is not possible for the amendment to be in addition to the 9.5-mile distance for a few reasons. The reasons I will share establish the importance of the January 1855 Grey Bruce map in relation to the timeline of events. It also establishes the importance of the declaration by Rankin that the amendment will not affect the terms of the treaty. Let me explain the reasons more in depth. Reason 1. Rankin already had made his intention clear on the Grey Bruce map that the northeast corner would terminate at Lot 2526 Main Street 7 months before the Copway Road amendment was agreed to, and 5 months before the Saugeen Band uprising. If an increase in frontage by distance along the shoreline is what is meant by the amendment, it can only be an increase in relation to the 8.1 miles from Lot 2526 to the original northwest position of the western boundary. This would bring the increase back to the original term of the treaty of 9.5 miles of shoreline, which would also be in agreement with Rankin's declaration of not altering the treaty terms. Reason 2. The referral to increased frontage is unclear and could possibly be describing the distance from the original western boundary outward towards the shore of Lake Huron. The chief had mentioned that at the time of signing Treaty 72, the band believed that they had agreed that Copway Road was the western boundary line, and they would receive everything north of that line. It would make more sense that the amendment memorandum is referring to the everything north of Copway Road as the increase in frontage on Lake Huron to convey the chief's statement as opposed to the distance from point A to point B. Reason 3. We know that the distance from the original northwest position of the western boundary to the amended northwest position is approximately 1.4 miles. Not an insignificant amount of increase considering the second amendment of the memorandum included with the Copway Road amendment. The second amendment described the changes to the Cape Croker Reserve at Hope Bay. It recorded and recognized 1 and 2 miles of frontages. If these frontages were worth mention, why wouldn't an increase of 1.4 miles in distance to the Saugeen Reserve be worth mention? Reason 4. The terms of the treaty would be changed to a shoreline measurement from 9.5 miles to 11 miles, which would be in conflict with Rankin's declaration of the treaty terms not being altered in any way. Reason 5. Rankin's final map of 1856 shows the amended western boundary following along the Copway Road path and the northeast corner of the Saugeen Reserve terminating slightly south of the Lot 2526 dividing line. The portion from Lot 26 to midpoint Lot 31 is not part of the reserve, and the lots to be sold are shown as terminating at the shore of Lake Huron. It is absolutely crystal clear. And the most obvious reason is because it is impossible for frontage to exist between Lot 26 and midpoint Lot 31. In Part 1, I showed that the eastern boundary runs through the water between these 2 points, making it impossible for a boundary to exist along the shoreline. There is no Saugeen boundary between Lot 26 and midpoint Lot 31, so how can the increase be in addition to something that doesn't exist? The argument is nonsensical. The whole reason for the Copway Road Amendment was to honor the treaty's 9.5-mile measurement and to give the Saugeen Band the boundary they thought they had agreed to in the first place. Now that the conditions of the Copway Road Amendment have been established, we can retest the boundaries of the Saugeen Reserve using the amendment terminology in combination with the original treaty instructions. Unbelievably, no one, to my knowledge, has ever done this test in all the time the Saugeen Band has been disputing the position of their boundaries. Several surveys since Rankin's original survey have been done, in the belief that Rankin positioned the eastern boundary in the wrong location. However, no one had simply tested whether the treaty terms matched the final map Rankin submitted. In 2017, I was the first. I will recreate this test once again to visually show you the results. Since the Copway Road western boundary is already located on the GPS Ontario mapping tool, I will use the mapping tool exclusively to retrace the entire Saugeen Reserve boundary using the amended treaty instructions. This time, the 9.5-mile measurement will begin from the amended western boundary at Copway Road. The first instruction from the treaty in its amended form would read, "All that block of land bounded on the west by the Indian path called the Copway Road, which takes a northwesterly direction from a straight line running due north from the river Saugeen, at the spot where it is entered by a ravine immediately to the west of the village, and over which a bridge has recently been constructed to the shore of Lake Huron." It is worth noting that the entire length of the original western boundary still remains within the boundaries of the Saugeen Reserve, even with the amendment in place. The second instruction remains the same, on the south by the aforesaid northern limit of the lately surrendered strip. Third instruction remains the same, however there is a new starting point. On the east by a line drawn from a spot upon the coast at a distance of about 9.5 miles from the western boundary aforesaid. As you can see, I have the Copway Road amended boundary in place, and I have the location where we want to begin our measurement of 9.5 miles. The treaty again says that you're supposed to begin here, but since it's easier to move the mouse down as opposed to up, we are going to start at lot 2526. So we'll just move our way up there, and we want to measure a distance in miles, and we are going to start right here. And there we have it, 9.5 miles right on the button. Incredibly, because I say incredibly just because I've done this measurement so many times, and I don't think I've ever had it come up to 9.5 right on the nose. But like I said before with the other one, it varies between 9.5 to 9.7, whatever. It depends on how well you do the shoreline, and it's not easy to manipulate the mouse to get it to the exact thing. So you're always going to have a variance. What's important? It's about 9.5 miles. The fourth instruction remains the same, and running parallel thereto until it touches the aforementioned northern limits of the recently surrendered strip. Although the western boundary takes a northwesterly turn at Copway Road, it still runs due north from the Saugeen River for 0.32 miles, which allows the eastern boundary to still run parallel. When I was measuring the 9.5-mile distance using both the original treaty instructions and the amended treaty instructions, I did so following the entire 9.5-mile shoreline. I did this to show that there was nothing corrupt in the way I approached the experiment. Both measurements were done fairly and the same. However, there is a much easier way to illustrate that both distances equal about 9.5 miles. Both measurements have this area of shoreline in common, so we know that that distance of the measurement is the same to both at 8.1 miles. All we need to do is measure from Copway Road to the original northwest position of the western boundary, and then also measure from Lot 2526 Main Street to midpoint Lot 31. Since these measurements are relatively the same, we know the amended treaty measurement and the original treaty measurement are relatively the same at about 9.5 miles. They may be relatively the same, but the distance from the original northwest position of the western boundary to Copway Road is slightly longer than the distance from midpoint Lot 31 to Lot 2526 Main Street. This is quite significant in connection to the Copway Road Amendment wording of "This will give the Saugeen Indians a small increase in frontage on Lake Huron." It is not in reference to the approximate 1.4 miles from the original northwest position of the western boundary to the Copway Road position. It is in reference to the 250 feet that was gained, an increase so insignificant and still within the range of about 9.5 miles, the distance wasn't worth mention. Remember, 1 mile and 2 mile frontages were mentioned in the Cape Croker Amendment. I used the 1855 draft map when I was tracing the boundaries of the Saugeen Reserve using the original treaty instructions. From that retracing, the conclusion was that the terms of the treaty did not match the boundaries of the Saugeen Reserve. The map the Saugeen Band claims clearly establishes their territory through survey and by the terms of the treaty. Keeping this in mind, I would now like to compare Charles Rankin's final map of 1856 to the tracing of the amended treaty boundaries of the Saugeen Reserve that I just performed using the Ontario Topographic Mapping tool. As you can see, they are a perfect match. In Part 1, I discussed the October 12, 1855 draft map, the Saugeen Band's key piece of evidence. I showed that the lines of the Saugeen Reserve's boundaries on the map don't match the original terms of the treaty. This, on its own, should be enough to defeat the claim of the Saugeen Band. The northeast corner of the territory is clearly defined as terminating in the vicinity of Lot 2526 Main Street on the draft map. An extension of the eastern boundary line is shown running through the water from Lot 26 to midpoint Lot 31. Making it impossible for the shoreline boundary and the eastern boundary to exist together. The reserve's western boundary isn't even shown to exist on the map. This is the same map that the Saugeen Band claims clearly matches their territory to the terms of the treaty and the survey by Charles Rankin. In Part 2, I discussed evidence never before considered in connection with the Copway Road Amendment. I established that as early as January 1855, Rankin made his intentions clear on the Grey Bruce map to locate the northeast corner of the Saugeen Reserve at Lot 2526, not midpoint Lot 31. This intention is clearly shown 5 months before the Saugeen Band's dispute regarding the location of the western boundary. If the amendment's mention of increase to the Saugeen Reserve's shoreline is referring to the entire distance of 1.44 miles, it is in addition to the 8.1 miles Rankin had already established as the shoreline boundary 5 months earlier, not the unachievable 9.5 miles stated in the original treaty instructions. This theory is corroborated by Rankin's declaration that the amendment would not alter the terms of the treaty in any way, keeping the shoreline distance as stated in the treaty at 9.5 miles, not 11 miles. I also showed that the increase mentioned in the amendment was more likely the minimal increase of shoreline that was gained from 1.4 miles to 1.44 miles, a distance approximately 250 feet in length, an increase so small that the actual distance was not worth mention, since the shoreline distance still equaled about 9.5 miles. This theory can be corroborated by the fact that Rankin's final map indisputably locates the northeast corner of the Saugeen Reserve at lot 2526, about 9.5 miles from the indisputable amended northwest position of the western boundary at Copway Road. So what about the documentation that seemingly corroborates the Saugeen claim? Having matched the treaty instructions to Rankin's final map, very little needs to be said beyond this point. It is difficult to give much credence to evidence which is secondary when the treaty terms have already been matched to the final map. However, since ANAC presented evidence that they declare corroborates the Saugeen claim, I will address these issues now. In 1856, Rideout and Schreiber, an engineering company, were doing survey work of their own at the Sauble River, the same year Charles Rankin submitted his final map to Indian Affairs. It is assumed that this company found the actual survey stake at midpoint Lot 31 and noted what was written on it. Their survey map has a notation at the Lot 31 post that reads, marked as northeast angle of Saugeen Reserve according to treaty boundary running south. Notations of this length on a post would be very unusual in Rankin's time, so whether Rideout and Schreiber were told the meaning of the survey stake, perhaps by Rankin himself, or they visually saw the notation on the post, it cannot be determined. There is a word following the word marked, and it appears to be as. I would interpret this to mean the location is marked as, not the actual post. No matter how it was conveyed to them, the notation is actually quite logical and makes sense, but it doesn't support the Saugeen Band's argument. Since notations on posts of this length were not the norm in Rankin's time, the first question I asked myself when I began analyzing it was, why is this notation so long, and does it make sense? At first I said no, but the more I repeated it to myself, the more it made sense considering the events surrounding the Rankin survey. If the notation on the survey post was to mark the northeast corner of the Saugeen Reserve, why would they add the words according to treaty boundary? Why go to all that effort to mark a post in this manner? Why wouldn't you simply mark it in the same way the 1855 draft map was marked, if it held the same meaning? Because it doesn't hold the same meaning. The 1855 draft map marks the same position in a concise manner. It simply says Northeast Angle Indian Reserve. When examining the physical post found at Lot 31, you would expect the post to appear something like this illustration I created, especially since there are several examples of surveying teams marking Indian reserves in this manner throughout Ontario. By adding the phrase, according to treaty boundary, it implies there is another location to be considered. Bearing in mind what I discussed about the Copway Road Amendment, the other boundary to consider is the relocation of the northeast corner to Lot 2526, Main Street. It is difficult to believe that Rankin would go to all the trouble of marking a post with an extravagant notation when he could simply match the map notation to the post notation as illustrated. When you visualize the post with the long notation as illustrated, It makes it almost unbelievable that this would have been done. I suggest that Rideout and Schreiber were told what the post meant, meaning there likely was no marking on the post whatsoever if they needed to confer with someone else to find its meaning. However, it makes no difference to the outcome. Logic suggests that the notation is conveying that the northeast corner of the Saugeen Reserve has been relocated from where the post is positioned. But there is further evidence to explain why the actual survey post could have been marked northeast corner of the Saugeen Reserve according to treaty boundary running south. When Rankin was in discussion about the width of the Saugeen Reserve, among his papers he had a sketch that included the western boundary. On it there was a notation. Where the original northwest position of the western boundary meets Lake Huron, he noted, by treaty. And where Copway Road was located, he noted, desired by Alexander. Alexander being one of the chiefs representing the Saugeen Band. This would suggest that when Rankin marked the Northeast Angle Indian Reserve notation on the 1855 draft map, he held the belief that midpoint Lot 31 would be the location of the northeast corner of the Saugeen Reserve, and made a note of it. However, by the time of the Copway Road Amendment, which was before the staking of the midpoint Lot 31 post, he makes a similar notation on the post as he did on the western boundary sketch. This similarity implies that, as he had moved the western boundary location to Copway Road, he also has moved the northeast corner of the Saugeen Reserve from midpoint Lot 31 to Lot 2526 Main Street. On the Lot 31 post, according to treaty boundary, and on the western boundary sketch, by treaty. There is absolutely no reason whatsoever for Rankin to add the phrase, according to treaty boundary, if the location marks the northeast corner of the Saugeen Reserve. It is unnecessary. The similarity in the notations indicate why he did so. So why would Rankin stake a post at midpoint Lot 31 at all, if it has no significance? The post actually held a lot of significance. A total of 9.5 miles of shoreline could not be achieved from the original treaty instructions, but Rankin knew he could still use the Lot 31 position to locate where the block of land does terminate, at Lot 2526. This could be a second reason the notation Northeast Angle Indian Reserve appears on the map. It is a note to mark a starting point for Rankin. Whether Rankin marked the notation during his initial traverse between the Saugeen and Sauble River in October 1854, or he marked it during the Eastern Boundary Survey in September 1855, both arguments offer sound reasoning for why it is there. Regardless of when the notation was marked, this was the location he used to find the actual northeast corner. He simply had to run the true north line south until the line left water and struck land. This is exactly what he did, as is recorded in his field notes. This was also a much more efficient way to find the location rather than traveling 9.5 miles from the northwest position of the western boundary at Copway Road. 2 miles of relatively flat sand terrain as opposed to 9.5 miles, the bulk of which is tree-filled, rocky, and on bluffs. He would have had to start at the mouth of the Sauble River to enable him to find the original northeast corner using his measurements from the October 1854 traverse from the Saugeen River to the Sauble River. Anak and the Saugeen Band also argue that Rankin's field notes, which were written by George Gould, refer to the midpoint Lot 31 post as the Indian boundary when identifying the location of the side road between Lot 30 and Lot 31. This is very misleading and selective information considering everything else contained in the field notes. Anak refers to one specific page from the field notes to substantiate the Saugeen claim. They don't mention any of the pages in the field notes that describe the side roads as you head north from the southern position of the Saugeen Reserve's eastern boundary. These pages don't corroborate or match what Anak is trying to prove with the Lot 30-31 side road field note page. Between lots 5 and 6, the side road runs 82 chains, 76 links from the concession C and ends with a post staked at the Indian boundary and marked with an X on the 1855 draft map. Between lots 10 and 11, the side road runs 78 chains, 65 links from concession C and ends with a post staked at the Indian boundary and marked with an X on the map. Between lots 15 and 16, the side road runs 75 chains, 8 links from concession C and ends with a post staked at the Indian boundary and marked with an X on the map. Between lots 20 and 21, the side road runs 70 chains, 92 links from concession C and ends with a post staked at the Indian boundary and marked with an X on the map. Between lot 2526 Main Street, Lake Huron is referenced where the side road ends. It simply says that a post was planted 1.56 chains or 103 feet from Lake Huron, but on the 1855 draft map, the X that marks the post is in the lake. No mention of an Indian boundary whatsoever. This means the side road at lot 2526 ends at Lake Huron, since it was Rankin's practice to place posts well inland from the lake so they would not be washed away. Between lots 30 and 31, the note reads that the side road ends 62 chains, 54 links from concession C at a post that is 1 chain, 72 links, or 114 feet from Lake Huron, a similar distance from the lake as is at lot 2526. Again, so the post won't be washed away by the lake. The lot 30-31 post has the added distinction that it is 10 chains south of post of Indian Reserve. It doesn't say 10 chains south of the Indian Reserve or 10 chains south of the Indian Reserve's northeast boundary. It says south of post of Indian Reserve. If indeed there was an Indian boundary 10 chains south, as Anak and the Saugeen Band claim, the lot 30-31 side road should have ended at the Indian boundary and marked with an X on the 1855 draft map, the same way the other side roads south of lot 2526 Main Street are recorded. The notation 10 chains south of post of Indian Reserve is simply a reference to the post Rankin used to find the northeast corner of the Saugeen Reserve. The post itself is the only thing that holds any distinction to the Indian Reserve. The post is not referenced as post of Indian Reserve's northeast boundary, and the lot 30-31 side road, 10 chains south of the post, doesn't end at the Indian boundary. It ends at Lake Huron, just like lot 2526. Furthermore, if we look at the field note page that describes the line of the Saugeen Reserve's eastern boundary, the title page is labeled Indian Boundary, west side of Concession D. The 1855 draft map proves that there is nothing west of Concession D other than Lake Huron from lot 26 to the post at midpoint lot 31. If you were to extend the eastern boundary line on the final map, you would find the same thing. There is no Indian boundary whatsoever west of Concession D shown on the 1855 draft map until you start heading south at the dividing line of lot 2526. These comparisons of the field note notations to the 1855 draft map are just as conclusive that the Saugeen Reserve's eastern boundary ends at lot 2526 as the Copway Road to Main Street measurement equaling 9.5 miles. Consider this. The midpoint lot 31 post referred to as post of Indian Reserve in the field notes was the starting point Rankin used to enable him to create the true north line. The line used to locate the northeast corner of the Saugeen Reserve 1.4 miles south at lot 2526 Main Street. The same location where the field notes describe the lot 2526 side road as ending at Lake Huron. He continued the eastern boundary on that same line south for another 7.5 miles to mark the eastern boundary of the Saugeen Reserve. The post at midpoint Lot 31 also represents the original intended location for the northeast corner of the Saugeen Reserve. The post, what it initially represented, and what it eventually was used for, was all in relation to the Saugeen Reserve's boundary. For Rankin and his assistant George Gould to refer to the midpoint Lot 31 post as the post of Indian Reserve is hardly any kind of revelation, particularly when all the side roads south of Lot 2526 end at an actual Indian boundary line that can be matched to Rankin's field notes. Rankin himself seemingly refers to the portion of beach from the Sauble River to Main Street as the Indian boundary. On September 4, 1855, Rankin and his men surveyed from the mouth of the Sauble River to just inside the northern boundary of Lot 25. This from Rankin's diary dated September 4, 1855. Commenced and ran down 2 miles on boundary of Saugeen Indian Reserve. We know that it is approximately 2 miles from the Sauble River to Lot 2526. We also know that the mouth of the Sauble River to midpoint Lot 31 is most definitely not part of the Saugeen Reserve boundary. Yet it sounds as if Rankin is referring to this portion as the Indian boundary. Overwhelming evidence, including the field notes, confirm that from Lot 31 to Lot 2526 Main Street is also not part of the Saugeen boundary. Therefore, Rankin's entry of commenced and ran down 2 miles has to mean to get to the Saugeen boundary. Rankin continues in his diary, and afterwards left the camp together with Claudia Skiing to return to the village to give general superintendence to other matters connected with the survey, leaving Gould to proceed with the Indian boundary and other parts of Amabel. 2 miles from the mouth of the Sauble River heading south puts you at Lot 2526. Rankin is at Lot 2526 when he makes his statement in his diary, and that is where their work is finished for that day. They stopped work for the day in the exact same location the northeast corner of the Saugeen Reserve is identified as terminating on Rankin's final map. The exact same location where Rankin left Gould to proceed with the eastern boundary of the Saugeen Reserve heading south. The exact same location that is about 9.5 miles from the northwest position of the western boundary at Cobway Road. The exact same location by scale that marks the northeast corner of the Saugeen Reserve on the Grey Bruce map. The same location the northeast corner of the Saugeen Reserve is shown to be on the 1855 draft map. These are not magical coincidences. These are the facts that confirm the northeast corner of the Saugeen Reserve terminates at Lot 2526. The last piece of evidence that Anak advertises as corroboration of the Saugeen claim is the Huff letter. Livingston Huff wrote a letter to Indian Affairs back in 1932, claiming that the shore in front of his lot, Lot 26, was part of the Saugeen Reserve. Mr. Huff was explicit in defining what he thought the boundary was. This is his description. We wanted the land right to the water, but there was about 10 acres between our lot and Lake Huron that was claimed as Indian Reserve, and the white people were made move off that strip right to the Sauble River. The first thing about this letter that jumps out at you right away is that this description does not match what the Saugeen Band is claiming. Livingston Huff says that the reserve is from Lot 26 to the Sauble River, and it equals 10 acres in total. The Saugeen Band claim that their reserve boundary should extend to midpoint Lot 31, and it is the exact width of the beach. Since Mr. Huff was kind enough to give the detail of 10 acres, I used this calculation to find exactly what his description equaled. Using this method to calculate the width of the shoreline Mr. Huff describes, I could identify what it equaled in feet. To illustrate this, Huff's description has the reserve going from Lot 2526 to the Sauble River at a width of 37.5 feet at the shoreline. The Saugeen Band claim the reserve extends from Lot 2526 to midpoint Lot 31, with the entire beach as the width. Hardly a matching description that can be considered corroboration of the Saugeen Band's claim. However, the Special Fishery License of 1874 is very close to matching what Mr. Huff is describing. The Saugeen Band purchased a special fishery license for the annual sum of $10 for a period of at least 10 years, from 1874 to 1884, described in the license as the area between the north side of the Sauble River and the dividing line of Lot 2526. Yes, there is documentation that proves the Saugeen Band willingly paid to use the area between the Sauble River and the dividing line of Lot 2526, the exact same area Mr. Huff described. The license also stated that this license is given for the whole band, and on the understanding that they will neither sublet nor take white men into partnership. The statement about white men being made move off the strip in the Huff letter appears to be a misunderstanding on Mr. Huff's part. Rather than white men being made to move off the strip, the license says they were not allowed to enter into partnership with the Saugeen Band, or sublet any portion of the licensed shoreline from the Saugeen Band to fish. By the wording of the license, white men were not allowed to fish 5 miles out on Lake Huron from the shore at the dividing line of Lot 2526 to the Sauble River. Because the term white men is used in the special fishery license, and it is used again by Mr. Huff, it creates a second connection between these two documents. Furthermore, Mr. Huff never mentions who told him of this condition to his lot. Nevertheless, if there was such a requirement, it was not mentioned in the Crown Patent to make it legally binding. The Crown Patent makes no mention of an Indian reserve in front of Lot 26, because there wasn't an Indian reserve in front of Lot 26. Indian Affairs were advertising and selling the lots from Lot 26 to Lot 31 as going to the water's edge. In 1910, 22 years before Livingston Huff's letter, a letter was sent to the Department of Indian Affairs regarding the sale of the north half of Lot 31 from a Mr. Ferguson, an Indian agent stationed in Wyerton. In the letter, he states that there is very little value in the lot as farmland. However, he adds, it has its value from the fact that it abuts on Lake Huron and has a nice bathing beach in front thereof, meaning the westerly limit of the lot extends to the shore of Lake Huron. This does not match with Mr. Huff saying the strip of land that was part of the Saugeen Reserve extended all the way to the Sauble River. If that were true, the north half of Lot 31 could not extend to the shore of Lake Huron, as Mr. Ferguson stated. Regardless of any speculation as to the hearsay of Mr. Huff's letter, the reply from the Department of Indian Lands and Timber to Mr. Huff is very clear and confirms what Mr. Ferguson was saying in his letter. Their reply states, as the department disposed of its interest in this lot by Crown grant many years ago, it is precluded from taking any action at this date. Any normal accretion would, of course, go to the purchaser or his assignee. So it certainly wasn't the government that told the white people to stay off the strip of land from Lot 26 to the Sauble River, and more likely it was the Saugeen Band themselves. The content of Livingston Huff's letter cannot be substantiated by anyone or anything, making it hearsay. Regardless, the government response dispels any question that the portion of land Mr. Huff describes was ever part of the Saugeen Reserve. This is another example of a NAC manipulating facts. They are trying to make it sound by the content of Huff's letter that it is common knowledge in 1932 the Saugeen Reserve runs north of Lot 2526 to midpoint Lot 31. There is absolutely nothing official to support or substantiate this conclusion, and further evidence from NAC's own predecessors of that time shows Mr. Huff is misinformed. If this were not enough, the Saugeen Band's own council minutes confirm that the band is very much aware that they do not have ownership of the area described by the special fishery license. In 1882, they passed a motion to have their Indian agent, John Creighton, ask the department to have the Sauble fishing station given back to the band. The Sauble fishing station is described in the special fishery license as the shoreline from the north side of the Sauble River to the dividing line of Lot 2526 and 5 miles into Lake Huron. Yet another reference to Lot 2526, coming 20 years after the signing of Treaty 72, confirming that the Saugeen Band knew the northeast corner terminated at Lot 2526. There is even evidence that a Mr. Plummer was trying to have a shoreline reserve created, but there is no evidence that he was successful. From the time he started his campaign, and for another 2 years until 1884, the special fishery license was the only thing that gave the Saugeen Band any privileges north beyond Lot 2526. There is no further documentation in regard to a shoreline reserve being created or the special fishery license being extended. The special fishery license did not include land at the shore for the Saugeen Band's use. It included from the shore out into the lake for 5 miles, nothing from the shore in and onto land. This would explain the phrase "precluded from taking any action" in the response to Livingston Huff in 1932. By 1858, many lots had been sold north of Lot 25 to the Sauble River, including Lot 28. Lot 34 was sold in 1871, and lots 27 and 29 in 1881. With all these lots already sold, the government would have been precluded from creating a shoreline allowance for the Saugeen Reserve in 1882. Regardless, the shoreline allowance, had it been created, was not intended to be a reserve of ownership for the Saugeen Band. Its purpose would have been this, as stated in Mr. Plummer's letter. The object would be not to prevent the settler free access to the water, but to secure the right to the Indians to land and cure their fish. The first line of Mr. Plummer's letter also confirms that it is common knowledge that the lots end at the water's edge, and that the special fishery license does not include access beyond the shore and onto the lots. Plummer states, "My attention has been called to the fact that some of the lots between lots 24 and 34 in Concession D in the township of Amabel have been sold for actual settlement, and that some of the purchasers thereof have interfered with the Indians in their fishing operations. The Indians' fishing ground is in front of these lots, and they cannot carry on their work without trespassing thereon." In other words, the Saugeen Band had a license to fish in the lake between Lot 26 and the Sauble River, but they had nowhere in the same area to land and cure their fish. This was Mr. Plummer's concern. A document describing the lots between Lot 26 and Lot 48 in Concession D contains basic details about the lots. It includes the sale number, the date of the patent reference number, and a small blurb about any restrictions to the lot. The earliest patents from 1858, most specifically Lot 28, stipulate that the lot owner must provide free access to the shore for all vessels, boats, and persons, making it clear the lots go to the water's edge. Lot 28 is one of the lots that makes up a portion of the beach the Saugeen Band are claiming. The later patents were shortened to establish that there is no reservation for a road allowance along the shore. The only exception is Lot 34, where there was a road allowance reserved along Lake Huron and the Sauble River. Rankin's final map shows all lots ending at the water's edge. So without any reservations applied to the lots, they all end at the water's edge, with the exception of Lot 34. Rankin's final map confirms it. The special fishery license confirms it. Mr. Plummer's letter of 1882 confirms it. Mr. Ferguson's letter from 1910 confirms it. And the reply to Livingston Huff in 1932 confirms it. Even the Saugeen Band's own council minutes from 1883 confirm it. The abundance of documentation prior, during, and subsequent to the Rankin survey that confirmed the location of the northeast corner of the Saugeen Reserve at Lot 2526 demonstrate the selective research process of Indigenous and Northern Affairs Canada. It would seem obvious that their research directive was to search only for documentation that supports the case of the Saugeen Band and simply ignore all else. It is impossible that they did not notice the significance of the documentation I have presented. For example, how can the Huff letter description, a description that doesn't even match the claim of the Saugeen Band, hold more weight in the eyes of Anak than the reply letter from a predecessor from their own department that denies Huff's belief? It is also inexcusable for them to have overlooked the 9.5-mile measurement from Copway Road. Their excitement over what they assumed certain documentation meant clouded their objectivity to include an accurate assessment of all documentation available. There is no other word to describe their investigation other than sloppy. This marks the end of my research. What I have learned over the last 3 years is that there is nothing overly complex about this case. There is nothing overly difficult to understand once you can interpret the treaty instructions and follow the timeline of events. There is nothing that supports the Saugeen Band's claim that cannot be explained and given a much less speculative explanation that ironically ends up supporting the defense. The Anak Saugeen Band argument that a shoreline measurement from the original northwest position of the western boundary to the northeast angle Indian Reserve notation equals about 9.5 miles is irrelevant when it is confronted with the Copway Road amendment. What is relevant is that the measurement from the amended northwest position of the western boundary at Copway Road to lot 2526 Main Street also equals about 9.5 miles. This is not a magical coincidence. It was a necessary adjustment to the shoreline position for the measurement to conform to the terms of Treaty 72. It actually confirms that the 1855 Saugeen Band's original understand of the treaty terms were correct. Over 160 years ago, the Copway Road Amendment solved the dispute we are having today. The research I have presented confirm it. Nonetheless, much will be made of the fact that I am not an expert, and it is expert analysis that is needed to determine what is meant by these documents and events. I will remind those who question my analysis that it was the publicly available evidence contained in the expert reports that allowed me to make my analysis. I will also point out that since there are two contending viewpoints, one of the experts is wrong. I will also point out that during my research, I had many conversations with experts that aided in my conclusions. I do not have to be an expert to make the connection that the two positions that are claimed to be the northeast corner of the Saugeen Reserve have a legitimate starting point from two different locations and both equal 9.5 miles. I don't have to be an expert to understand why it is impossible to contain the midpoint Lot 31 9.5 mile measurement within a block of land. I don't have to be an expert to understand the importance that not one of Rankin's maps shows an actual boundary line of the Saugeen Reserve ending at midpoint Lot 31. What is most significant, I am the only one who has matched the treaty terms in their amended form to the final map Charles Rankin submitted in 1856. Since analysis of Rankin's survey began in the late 1800s, no expert report has ever considered whether the treaty terms were met. I have made no speculations or assumptions. I have conclusively matched the amended treaty terms to the final map. However, if it is expert opinion that is needed, I would be more than happy to put my research up to the scrutiny of an unbiased expert. I have even made my research available to the federal and provincial governments and have asked to have an expert either confirm or deny my findings. So far, I have not been taken up on that offer. The expert who prepared the 2006 report that supports the defense now works for the federal government. Anak should have no objections to having my research analyzed by him, since his expertise is trusted enough to allow him to be employed by the federal government of Canada. After listening to this presentation, you may be interested in an overview of the 27 years that I have been involved in this claim. Since everyone has bought into the enact Saugeen Band argument for so long, no one wants to accept new information. I have been met with much resistance to any of the evidence that I have uncovered right from the word go. My first discovery regarding the Huff letter wasn't even discussed, and at this point it appears my last 3 years of research is being met with much resistance. The government departments continue to hide behind the legal system, leaving me with no access. Since this claim is part of a legal process, they don't have to answer any of the questions I have raised. It is important to note that although Canada is in full support of the Saugeen Ojibwe First Nation land claim, they are also a defendant in this case. Inexplicably, as a defendant, the only department the federal government of Canada assigned to do any sort of research into this claim was, and still is, Indigenous and Northern Affairs Canada, a department whose mandate is to look out for the good of the Aboriginal people. This conflict of interest is an injustice to non-Aboriginal people in Canada. I think by the evidence presented in this video, it is easy to see why. The litigation is still an ongoing process that officially began for me in 1995 when the Saugeen Ojibwe Nation named me in their lawsuit and declared that my property was part of the Saugeen Reserve Number 29. I have had legal counsel regarding this issue since 1992. At the time of this production, I have been defending my right to my property for almost 27 years. Yes, you heard me correctly, 27 years. My marriage and my children have known nothing other than the conflict put forth to me by the Saugeen Band, claiming my property, our property. The government claims that Aboriginal treaty issues are so complex that it takes years to consider all the information from well over 150 years ago and what the intention of each action taken had on the eventual outcome. But let's be clear. This case isn't about whether Indigenous people were coerced or even tricked into surrendering the Saugeen Peninsula, what is now known as the Bruce Peninsula. It is about whether the Saugeen Band received the proper boundaries to their reserve that they were promised in Treaty 72. This does not take over 30 years to establish. Think about that, 30 years. It does, however, take a thorough, accurate, and competent investigation. There have been long stretches where this case has lain dormant. For example, after the 2006 mediation, the files of this action weren't dusted off again until 2012. Lawyers, judges, and the legal system in general are working on many cases at the same time. Whatever is the hottest issue is what gets attention. This particular case has garnered very little attention, and as a result, no one has felt any pressure to move this along in a timely manner. Compare this to the high-profile land claim in Sarnia that took 5 years from when the action was filed in 1995 until a decision was rendered in 2000. So please, don't be deceived into believing they are discussing this case and its complexities on a daily basis. I would doubt that since ENACT's initial research, the amount of time dedicated to this land claim equals 2 years in total. For me, it boils down to this. I have a deed that is registered with the Land Registry of Ontario, which can be traced back to the original grant of the Crown Patent. In other words, I hold legal title to my property without any form of ambiguity, yet I am still required to defend my title. This goes directly against the policy of the Specific Claims Guide issued by Indigenous and Northern Affairs Canada. Under the subheading Compensation, item number 8 states, in any settlement of specific Native claims, the government will take third-party interests into account. As a general rule, the government will not accept any settlement which will lead to third parties being dispossessed. In other words, the government will not accept any settlement that will deprive someone of land, property, or other possessions. No one from the government has ever explained to me why this policy has not been enforced in this land claim. As a matter of fact, from day one, no official from the government, federal or provincial, has ever contacted me to explain anything about my rights or how I should proceed in this matter. I'm confident that the same could not be said of the Saugeen Band. This precedent-setting case is trying to establish that Crown patents that were obtained through Indian affairs are not safe from native land claims. Early in the negotiation process, Canada could have struck a deal that would have seen the Saugeen Band owning the beach from Lot 26 to midpoint Lot 31 in the early 2000s. At that time, the landowners and the town were willing to give up their properties for reasonable compensation because we were manipulated into believing that that was our best and only option. The amount of money that has been spent on this claim from that day forward would have covered any proposed compensation package the landowners would have received many times over. However, Canada didn't see it as their obligation to compensate anybody. They went the other route, and during the 2006 mediation, they expected us, the private landowners, to give up our properties without compensation. I would have to relinquish my ownership, which would include my building, but worst of all, no compensation. All we would be able to do is use the property as we had used it in the past. Most likely, it would have been a lease agreement like they have on the Saugeen Reserve with the cottage owners. The exception being that I would no longer own my building, leaving nothing for me to sell. This is how the federal and provincial governments wanted to secretly mediate a settlement with people who had legal registered deeds that could be traced to Crown patents. Shameful. What did come out of the mediation of 2006 was an expert report that didn't agree with the federally supported Saugeen land claim. All the defendants in the claim, for the first time, realized that there was another side to the story contrary to the one provided by the federal government of Canada. There was much to comprehend and examine in the expert report. 13 years later, as much as I agree with and respect the expert report, I felt that it didn't answer three crucial questions that would conclusively prove that the Saugeen claim was unfounded. That being said, without the expert report, I would not have been able to begin my own research, which eventually did answer the three crucial questions. As I said earlier, it does not take over 30 years to establish whether the Saugeen Band received what they were promised in Treaty 72. However, as you can see by this case, an Aboriginal band should have to prove their case conclusively before they are allowed to make a claim. The system we are currently working under is dangerous and unjust. ENACT's research and support of the Saugeen claim is based on a manipulation of the facts. There needs to be a reform of how land claims are handled to protect non-Aboriginal Canadians. If Canada and the Saugeen Band had accepted the proposal for the landowners and the town to give up their properties in exchange for compensation in the early 2000s, this case would have been closed without any further research. The Saugeen Band would already own the stretch of beach from Lot 26 to midpoint Lot 31, and no one would be the wiser. As you have seen in this presentation, on the surface and without proper investigation of the northeast angle notation, the Saugeen Band's argument is convincing. Without the expert research that followed and the research that I was able to conduct because of that report, the facts of history would, and still may be, changed forever. Even if you don't accept my argument as conclusive, it at least proves that the ENACT Saugeen Band argument is anything but conclusive. It is time for the federal government to get control of the Department of Indigenous and Northern Affairs Canada. If it is an injustice that Aboriginal people have lost land that they may have been entitled to, it is equally unjust to dispossess Canadian citizens of land that they have legally purchased and are entitled to through Crown patents. Treaties and Crown patents should be respected in the same way. It is not my intention to make light of Native issues, but it is insulting that what my family and I have had to endure for 27 years and what we could stand to lose due to this land claim is of little significance to the media, the public, and the government. Compare what is known about our circumstance to the bombardment of politically motivated reporting on the ill treatment of Aboriginal people. Any publicity we have had through local media is publicity I have sought out on my own or created myself through my blog. I have never been sought out or questioned by the media by their own accord. I have also had to seek out government assistance on my own. My local representatives have had little influence over the powerful government departments that control this claim. My complaints fall on deaf ears. The fact that I am having extreme difficulty having anyone with any influence listen to me speaks to the inconvenience I have caused to the politically driven policies regarding Native issues and how they would like for this case to evolve. It is unacceptable when the Department of Indigenous and Northern Affairs Canada knowingly withholds evidence in an attempt to mislead the public into believing a treaty has been misrepresented. Not only did they do this internally within this investigation before the expert rebuttal in 2006, but they came to Sauble Beach and Wyerton in 2014 and publicly presented information that they knew was not complete. This is known as obstructing justice, the crime or act of willfully interfering with the process of justice and law by furnishing false information in or otherwise impeding an investigation or legal process. They did this to sway public opinion to the Saugeen Band's argument in the hope they could gain support for a mediation proposal that was anything but in the interest of the residents of Sauble Beach. During the meeting, ENAC only presented documents that support the Saugeen claim and never revealed documents that opposed the very information they were presenting. Rankin's final map of 1856 was never presented. The expert report and all the evidence it contains that is contrary to the Saugeen Band's argument was never presented. The government response to Huff's letter was never presented. The 6 pages of field notes were never presented that contradict their suggestion that the reference to the post of Indian Reserve is a reference to the actual Indian boundary. There are even 2 separate accounts that confirm that during the meeting, the lawyer who represents Indigenous and Northern Affairs Canada referred to the October 12, 1855 draft map as the original and final map. Where I'm from, this is known as lying. From the information I've presented in this video, you know the 1855 draft map is not the final map. The final map was completed in 1856, submitted and stamped file number 862 by Indian Affairs as the official survey plan of Amabel Township, now known as the town of South Bruce Peninsula. It matches the original treaty terms in combination with the Copway Road Amendment in every way. Conclusive evidence that all concessions were made to ensure that the Saugeen Band received all they were promised in October of 1854 through Treaty 72.